Hi friends, good morning. Welcome to Shankaran IA Study Circle. This is Dr. M. Harinath Reddy, Director of the Institute. Today in this particular video, we will try to discuss yet one more question on Indian polity and constitution. The question is something like this. Do you think that the Indian constitution is not based on the strict separation of powers, rather it is based on the theory of checks and balances? Do you think that the Indian constitution is not based on the theory of strict separation of powers, rather it is based on the theory of checks and balances? So this is the question. Let us try to discuss. And the theory of separation of powers, what is this? Theory of separation of powers. Theory of separation of powers. And similarly, there is one more theory. These two theories are interrelated. Keep that in mind. Theory of separation of powers and the theory of checks and balances. Theory of checks and balances. See, these two theories were given by an important French philosopher, Montesquieu, French political thinker Montesquieu, in his book Spirit of Laws. In his book Spirit of Laws. So there were two theories known by the names, the theory of separation of powers and the theory of checks and balances. Who gave these two theories? These two theories were given by a French political thinker by the name Montesquieu in his book The Spirit of Laws. Then what is the background under which these two theories were given? So these two theories were given by Montesquieu well before the French Revolution. So French Revolution, it happened in 1789. And what is the importance of French Revolution? So it is because of the French Revolution, the absolute monarchy in France is replaced with a republican constitution. So the absolute monarchy in France was ended through this revolution and a republic came into being. And by this time, when Montesquieu was writing about the theory of separation of powers and the theory of checks and balances, France is being ruled by a dynasty called Bourbon dynasty. Bourbon dynasty. And this dynasty, the rulers of this dynasty are very absolute and autocratic. By this time, there are no separation of powers. All the three powers of the government were exercised by the king or the queen. The executive powers, the legislative powers and the judicial powers are combined in one institution, that is the king or the queen. The king is the lawmaker, the king is the law implementer, the king is the law interpreter. So because of excessive concentration of authority in one institution, that is king or the queen, the kings of that time, they behaved in an autocratic manner and absolute manner. And as a result, there was danger to the rights and liberties of the people of France. It is not just a danger, it was real. Many of the sections of the French society, they were deprived of the political rights and liberties. This is because of excessive concentration of powers in one institution, that is the king or the queen. So keeping this in background, Montesquieu was trying to give a formula how to protect the rights and liberties of the people of France. For this, he has given two theories, the theory of separation of powers and the theory of checks and balances. The theory of separation of powers says that the powers of the government, all the powers of the government must not be concentrated in one institution, and instead these powers shall be divided into three types. He says the powers of the government must be separated into three categories: executive, legislative, judicial. So Montesquieu makes an argument that the powers of the government must be separated, and these powers must be entrusted to three different organs of the government, which he calls by the names executive, legislature and judiciary. So Montesquieu says legislature must do lawmaking, executive must do law implementation, and the judiciary must do law interpretation. So this is called the theory of separation of powers, that is dividing the powers of the government among the three organs of the government. In addition to the theory of separation of powers, this man also gave the theory of checks and balances. Theory of checks and balances. Along with the theory of separation of powers, Montesquieu also has given a theory called the theory of checks and balances. So the purpose of the first theory is to prevent concentration of powers in one institution by separating the powers and giving them to the three organs of the government. The purpose of the second theory is to ensure that there is balance of power among the three branches of the government. So the theory of checks and balances aims at preventing one organ becoming extremely powerful at the cost of the remaining two organs. So the theory of checks and balances says that each organ must exercise control over the remaining two organs so that there is balance of power among the three organs of the government, and then there is balance of power among the three organs of the government. These are the two theories given by Montesquieu. And the first written constitution and the first federal constitution in the world is United States of America. It is that of United States of America. The founding fathers of the American Constitution, they are quite impressed with the two theories propounded by Montesquieu. In fact, the theory of separation of powers and the theory of checks and balances were employed by the founding fathers of the American Constitution in the American Constitution. So today, the American Constitution, it is based on the theory of separation of powers and also the theory of checks and balances. But the question is, when it comes to the context of India, do we really follow the theory of separation of powers? Do we fully follow the theory of separation of powers? Before we discuss this, let us discuss what is there in American system. See, in the American system, the executive branch, it includes the American president and his cabinet colleagues, and the legislative branch includes the American Parliament, which is known by the name American Congress. The American Parliament is called Congress. And it has two houses, House of Senate and House of Representatives. House of Representatives. So the American system had a presidential democracy in place, and this presidential democracy, it is based on the theory of separation of powers. For example, in America, the American president shall not be a member of American Parliament, and the cabinet colleagues of the American president shall not be member of American Parliament. But in India, the Prime Minister and the Council of Ministers, they shall be members of Parliament. So in America, there is a separation of the executive and legislative branches along with the judicial branches. But in India, there is a fusion, overlap between the executive and the legislative branches. Because in India, a political party or a group of political parties which command majority in the lower house will form the government. In other words, in a country like India with a parliamentary democracy, the executive branch of the government, it is drawn from the legislature. But in America, it is not that case. In America, the American president forms the executive branch. The American president is separately elected by an electoral college, and he has a stable tenure of 4 years. Within 4 years, the American president is elected for a tenure of 4 years. Within 4 years, the American president cannot be removed. The American president cannot be removed through no confidence motion. In fact, in America, there is no system of no confidence motion. There is only one ground on which the American president can be removed, that is, he can be impeached for the violation of the Constitution, but otherwise, the legislative branch cannot remove the American president. He has a fixed tenure of 4 years. That's the reason why presidential democracy in America gives political stability. But in India, that is not the case. The executive branch of the government can be removed at any point of time by the lower house, that is the Lok Sabha, by passing a no confidence motion. That's why one of the demerits of the parliamentary democracy is political instability. So here the point is, in America, there is a separation of the executive and legislative branches, which is a presidential democracy. But in all the parliamentary democracies, there is fusion of executive and the legislative branches. In America, the American president cannot dissolve the lower house. He cannot dissolve the upper house. But in India, a prime minister who commands majority in the lower house, if he recommends to the president of India for dissolving the lower house, then the lower house shall be dissolved. So here you see the relationship between the executive and legislative branches. Executive branch and the legislative branches, they are fused. That's why we say that the Indian Constitution is not based on the Indian Constitution is not based strictly on the theory of separation of powers, because I told the Prime Minister is member of Parliament, the ministers are members of Parliament, and the executive branch provides a leadership in the Parliament. And most of the bills in the Parliament, they are introduced by the ministers in the government. And in addition to this, Prime Minister who commands majority in the lower house can get the lower house dissolved. Similarly, Lok Sabha can get the government removed by passing no confidence motion. So here there is a fusion of executive and legislative branches. Executive branch, it is drawn from the legislature, and the executive branch is accountable to the Parliament. So this is absent in the American system. That's why we say that in India we don't have a strict separation of powers, because India being a parliamentary democracy, one of the unique features of the parliamentary democracy is fusion of executive and legislative branches. Instead, Indian Constitution is based on the theory of checks and balances rather than the theory of separation of powers. Then how this theory of checks and balances works in India? For example, in India, the judiciary exercises control over the executive and legislature. For example, all the actions of the executive branch must be in conformity with the Constitution of India. If it is against the Constitution, if it is against the fundamental rights guaranteed by the Indian Constitution, then all the executive actions can be declared as constitutionally invalid by the Supreme Court and the High Courts by applying the power of judicial review. Similarly, all the laws made by the Indian Parliament, all the ordinary laws made by the Indian Parliament must not be in conflict with the fundamental rights. In case these laws are in conflict with fundamental rights, these laws can be struck down as invalid. It is not only that, even the constitutional amendment acts made by the Indian Parliament, if they are against the basic features of the Indian Constitution, the Supreme Court can strike down even the constitutional amendment acts made by the Indian Parliament under Article 368. So that's how in India the judiciary exercises control over executive and legislature. This is nothing but the theory of checks and balances. In addition, Parliament also exercises control over judiciary. How? The judges of the Supreme Court and the High Court can be removed by the Indian Parliament through a special majority. The judges of the Supreme Court and High Court can be removed by the Indian Parliament through a special majority. What is that special majority? A majority of the total membership of the House and a majority of not less than 2/3 of the members present on voting. So this is how the legislature exercises control over judiciary. In addition to this, I told the executive branch of the government can be removed by the Parliament through no confidence motion. That's how the legislature controls executive. In addition to this, when the Parliament meets in session, then the Parliament exercises control over the executive through a number of tools like the question hour, zero hour, confidence motion, no confidence motion, cut motion, etc. This is another way how the parliament exercises control over the executive. In addition to this, the emergency powers of the Indian executive, the emergency powers of the union executive under article 352 relating to national emergency, under article 356 relating to state emergency, under article 360 relating to financial emergency, they are subjected to the control of the parliament. That's how the parliament exercises control over executive. So we have seen how the judiciary exercises control over executive, how the judiciary exercises control over the parliament. Similarly, how the parliament exercises control over the judiciary, how the parliament exercises control over the executive. Similarly, executive also exercises control over the judiciary. How the judges of the Supreme Court and High Courts, they are appointed by the President of India in consultation with the Chief Justice of India and four senior most judges in the form of collegium. And even the transfer of the judges from one High Court to another High Court is done by the President of India. That's how the executive controls the judiciary. The executive also controls the parliament. How? The Prime Minister of India, who commands a majority in the lower house, if he recommends to the President of India for dissolving the lower house, then the President is bound to dissolve the lower house. That's how the executive exercises control over parliament or the legislature. So in other words, in India, the Indian constitution, it's based more on the theory of checks and balances rather than the theory of strict separation of powers. India being a parliamentary democracy, instead of separation, there is a fusion of executive and legislative branches. So we don't fulfill the condition of the strict separation of powers because of being a parliamentary democracy. But there is the theory of checks and balances very much ingrained in the provisions of the Indian constitution. So that's why we can conclude saying that Indian constitution is based more on the theory of checks and balances rather than the theory of separation of powers. So the theory of separation of powers is fully implemented in the American constitution but not in the Indian context. But despite all this, the Supreme Court of India in a number of cases said the theory of separation of powers and the theory of checks and balances, they are basic features of the Indian constitution. The theory of separation of powers and the theory of checks and balances, theory of checks and balances. The Indian Supreme Court in a number of cases said that the theory of separation of powers and the theory of checks and balances, they are basic features of the Indian constitution. What does that mean? Even the parliament under article 368 cannot amend, cannot take away these basic features. So for the final conclusion for this question is, the Indian constitution, it is rather based on the theory of checks and balances rather than on the theory of separation of powers as explained by Montesquieu. So that's it about this question. Thank you.